Well, good afternoon, everybody, and welcome again to another segment of our series of Directly from the Director. And today's installment, we're going to hear from Marcia Waters, the Director of the Division of Real Estate, and she's going to talk about the division's complaint and investigation process. We did survey questions from those of you that registered and are attending, and if we have additional time, we'll take some more questions through the chat. Also, we will be recording today's presentation, so if you want to get a recap later, give us a day, we'll have that link for you. So I hope you enjoy this today on a nice day here in Colorado, and I'm going to turn this over to Director Waters.
Well, good afternoon. So our duties are not just licensing real estate professionals, but once they're licensed, we have to make sure that they adhere to the professional standards that are established in state statute. And those are different for the three different licensing programs that we have. We have the real estate brokers, the real estate appraisers, and the mortgage loan originators. And they, like I said, they all have different standards. But the complaint process is similar for all of our programs. And one of the things to keep in mind is we are a consumer protection agency, but when we deal with complaints, we are not serving as an advocate for either the consumer or the licensee. The investigators serve as neutral fact finders, and then their findings, if it looks like the license law has been violated, those go to the representative boards or commission, and it's the boards or the commission that actually make the disciplinary decision about what to do with the licensee that's violated the license law. So when you file a complaint with us, we require that complaints are filed in writing. If for some reason you are unable to do that, like due to medical reasons, reach out to us and we can make other arrangements. But it is actually in statute that complaints must be submitted in writing. When we get a complaint, what we do is we will review it to see if we have jurisdiction. And that's where the practice standards enumerated in the statutes comes into play. So like if you're dealing with a real estate broker and you don't feel like they represented your interests as they should have, that's going to speak to brokerage relationships. And that is something that the Real Estate Commission does have jurisdiction over. Now, if your complaint is that your broker is, regularly late to appointments, unprofessional, dresses, doesn't dress nicely, uses profanity, that's not something that falls into the Real Estate Commission's jurisdiction. And I'll give you an example for each program, just so that you know. Like with the appraisers, if you have a complaint about, well, my property is in Boulder and it looks like the appraiser used comparable properties from Breckenridge, that's probably going to be an issue because those are two different types of markets. And the appraiser should have been using comparables most likely from the Boulder area only because that's where the property is. If your complaint is, well, the appraiser didn't hit the value that I needed in order to refinance my house, the board doesn't have jurisdiction over value. So the board's only going to look at issues related to how that appraisal was developed and communicated. So value alone is not something that the board has jurisdiction over. With mortgage loan originators, one of the common complaints that we'll hear about them is, my mortgage loan originator quit speaking with me. I couldn't get in touch with them. I lost my loan lock. That would speak to a mortgage loan originator probably being unworthy and incompetent, and that is something that we would open up and investigate. Now, if the complaint is that, I submitted all my documentation and the lender denied my loan, that's not something that we're going to have jurisdiction over. So just to kind of give you an idea of what we look at, first, we have to ascertain if we have jurisdiction over the substance of the complaint. If we don't have jurisdiction over it, we will notify you that we don't have jurisdiction. There is an opportunity for you to provide additional information if it looks like your complaint was incomplete, and we'll reassess that information. And then if we determine that there is jurisdiction over the additional information, we can open up and investigate it. If there isn't, we're still just going to close it at intake. If we decide that there is jurisdiction, it will then get assigned to an investigator. And to give you an idea, so the investigation section in the division is the largest section that we have. It is comprised of 4 lead investigators, and those 4 leads, for the most part, have oversight of the investigators themselves. We have 3 financial examiners on staff. They review broker accounts to make sure that those comply with the license law. And then we've got 15 investigators. So it'll get assigned to an investigator. The investigator is going to send out a notification letter to the licensee, because each of our regulatory programs has a regulation that says that when a complaint is filed, the licensee has to respond to the complaint, and they also have to provide supporting documentation. And usually supporting documentation is the transaction file for a real estate broker, the loan file for the mortgage loan originator, or the work file for the real estate appraiser. Once we've gotten the response back, that's when the investigator is going to look at starting to conduct interviews. They're going to look and see if there's additional documentary evidence that they can gather. And sometimes we will issue subpoenas for bank records, or we'll issue them to title companies. They'll interview witnesses. And once they have covered kind of all the bases of investigating that complaint, in most instances, they are going to draft an investigative report, and that investigative report is what a board or commission will then review to try to decide whether they're going to make a disciplinary decision in a case. There are some instances when we don't have any evidence to support a violation of the license law that we may not write a report. We may just issue a letter saying, we did our investigation, but we didn't find anything wrong. And then there's also kind of technical violations where we won't write a full-blown report on it. We will address that in some written correspondence to both the complainant and the licensee about, this is the technical violation that we found, and this is how the board has decided to deal with it. But those are kind of rare. For the most part, the investigators will write up a report. It will go to the board if it appears that the license law has been violated, and the board or the commission is going to make a decision on what to do with a licensee. And there's a lot of different factors that they evaluate when they are deciding to render discipline. So they're going to look at consumer harm, and when they look at consumer harm, they might evaluate, how large was the consumer harm, or how detrimental were the actions to the general public or that specific consumer. They're going to look at, were there prior violations on this licensee's history? Is there a pattern of conduct? They'll also look at how long the person's been licensed. The real estate broker program is unique in that there's supervision requirements for the real estate brokers. So if you've got a brand new broker, they might be looking at, well, were they properly supervised by their supervising broker? So when they decide if they're going to impose discipline, they can do anywhere from a letter of admonition, which is like a warning letter. It basically says that they found a violation of the license law, but they don't think that it's worthy of formal discipline, all the way up to revocation and imposition of fines. And before I go into kind of the disciplinary process, just to kind of give you guys an idea of what the timeline is for an investigation to occur. So it's in the performance plans of our investigators that they complete their investigations within 240 days or 8 months, although we have an average that we want them to complete them in that is lower than that. So the 8 months is supposed to be the max. Typically, statistically, based on our complaint stats for last month, it looks like it's taking them about 138 days average to complete an investigation, and that's for all 3 of the programs combined. And the completion rates are really going to depend on the complexity of the case and also the workload of the investigator. If we have a time where we are getting a high volume of complaints in, that can cause delays in getting complaints completed just because they're managing a higher volume. If we're looking at a case that involves, a lot of different transactions, that's going to take longer. If there's a criminal investigation going on, that could delay the investigation of our case. Sometimes law enforcement will ask us to kind of back off so that they can proceed with with their criminal case, and we will do that. There's just a lot of different factors that can go into how long the actual complaint process takes. So we've got the standards for the investigations. There's different standards once the board and the commission have made their disciplinary decisions. So when they decide that they're going to discipline somebody's license, the case then transfers from the investigation section over to the expedited settlement program. The expedited settlement program is an in-house program that is designed to try to resolve our disciplinary cases without having to expend litigation services through the Attorney General's office, because the Attorney General's office serves as the legal counsel for all of our boards and commissions. So they're going to try to settle the case first. So it's not immediate. If one of our boards says we're going to revoke a license and impose maximum fines, by no means is it immediate. The licensee, it's basically considered an initial offer for settlement, and the licensee can accept it, or they can choose to go through the administrative hearing process and exercise their due process rights. But first, kind of expedited settlement is going to try to get it resolved. We have some parameters where we can resolve things on behalf of our boards or commissions. It also gives the licensee an opportunity to submit additional information to the board or commission that maybe they didn't provide during the investigative process, or that they feel that the real estate commission or the boards didn't consider when they were making their decision. And they can submit a counteroffer to see if our boards or commissions will accept their counteroffer or do discipline that's kind of alternative to what they originally sought. If they sign the agreement with the expedited settlement program, the case will then end there, and that's when our complainants can find out about what the ultimate resolution was. If they choose not to settle their case with the expedited settlement program, what will happen is we will then refer it over to the Office of the Attorney General, and they will start working on notice of charges, which is part of the administrative hearing process. So they will take it to the Office of Administrative Courts, and it will be heard. The case will be heard by an administrative law judge, also referred to as an ALJ. And it's just much like a court proceeding. If it goes to hearing, they are going to call witnesses, take testimony, present evidence to the administrative law judge. And then the administrative law judge is going to issue an initial decision with their findings of fact and conclusions of law. What makes this process a little different than I think the court process that most of us are somewhat familiar with, whether it be criminal or civil, is when the initial decision is issued, it then goes back to the respective board or commission, and the board or commission can evaluate the findings in fact and conclusions of law. And if they don't think that the ALJ made the correct decision, our boards or commissions can basically appeal it, as can the licensee. So that starts the appeals process, which in the administrative realm is the exceptions process. So with the exceptions process, what happens is the appeals are filed, and it's not our actual board or commission that files the appeal. It's staff that does it on their behalf, because when they go through the exceptions process, the board or the commission is going to then sit in judgment like a judge would, and they will listen to each side's argument about why they are deserving of an appeal. After they go through the exceptions process and go through the exceptions hearing, then our board or commissions will make a determination, and then they'll issue a final order, and it's a final agency order. After that's been issued, and that is when the discipline will go into effect. And it goes into effect if ESP, our expedited settlement program, has gotten a signed resolution. But the final agency order, that's when the discipline also goes into effect. Now, if they issue a final agency order and the licensee is still unhappy and wants to appeal that, at this point, their remedy for repeals is going to the Court of Appeals. This doesn't happen too often that we have people actually appeal cases to the Court of Appeals, but we have had many more disciplinary cases where the exceptions process is being pursued, and it's being pursued on both sides, either on the board side or on the licensee side. And if you're interested in seeing that process in play, I would definitely encourage you to look at the board meeting agendas or the commission meeting agenda as well, because we will denote on there when there's an exceptions hearing, and you can kind of see that process play out. An administrative hearing is also open to the public, although I don't think too many people show up for those. But it's all very transparent, and licensees do have the right of due process to appeal a disciplinary action, or have their day in court if the board or commission is trying to impose discipline on them due to a license law violation. And I think I've covered everything in the slides so far. So Jeff, should we move on to questions?
Yes, Marcia, thank you. We did have quite a bit of questions come in, and you answered some of them, but there are still a few outstanding. So I'm going to go ahead and start at the top. They're not in any particular order. Does CREC first determine if it's a prima facie case, or does a complaint automatically shift the burden of proof to the agent? Not sure exactly what they're asking there, but I think generally they're asking where does the burden of proof lay?
So there's two instances where we're going to have prima facie evidence right out of the gate, and that's a criminal conviction or license discipline out of another jurisdiction. And all of our licensing programs have similar requirements as far as those two things. So there's a laundry list of criminal convictions or pleas of guilt or pleas of no contest that our boards and commissions can discipline your license over. Or if you're licensed in multiple jurisdictions and you commit a license law violation in that other jurisdiction and it's comparable to something that would be a violation here, our boards and commissions can discipline you for that. And all they have to have is basically proof of that conviction or that disciplinary action. Everything else, it's not that the burden is on the respondent, and that's what we call the licensee who's had the complaint filed against them. The burden of proof is on the board or the commission. So they have to be able to prove their case. And if we can't prove a case, it's not going to move forward. So ultimately, with a complaint, the burden of proof is on us to be able to prove. And what you also need to realize is the standard of what we have to prove. It's not proof beyond a reasonable doubt. It's a preponderance of the evidence. That is our threshold for proving.
Okay, thank you. How long does a disciplinary action remain on a licensee's record?
So disciplinary actions are forever. It just depends, and it's also going to depend, like what will show up in a license is a little different than disciplinary actions in general, because that's a particular type of discipline that's been imposed. So you're not necessarily always going to see the license discipline if you look on our website. But if somebody's been disciplined, we keep those records for forever. So if somebody submitted an open records request about a disciplinary action from 15 years ago, we still have that document on file, and we're going to release it.
Okay. I think Cora might come into play in this next question. If there's ever been a complaint filed against a realtor, even if they were declared innocent, does it show up somewhere? So
we can tell if there has been a complaint dismissed against one of our licensees. The public cannot. And also, our statutes only say that what we will release under the Open Records Act is stipulations and final agency orders. So if somebody submitted a CORO request, open records request, saying, I want to know how many complaints have been filed against Marcia, and Marcia has 20 dismissed complaints, we're not going to release that information to you because it's protected under CORA.
Gotcha. Thank you.
Or under our statutes, that is.
Gotcha. When should an agent recommend to a consumer to go through the complaint process based on what that agent is being told about another broker?
So I think it's really going to depend. as far as timing is concerned, is as far as what the individual feels comfortable with. If they're concerned that if they file a complaint while the transaction is ongoing, that it may have detrimental impacts to the transaction, they may want to wait until after the transaction closes and then file the complaint with us, or they may choose to move forward. I think the important thing to keep in mind has to do with the statute of limitations as far as when we can investigate complaints or take action. And really, the statute of limitations goes back to when the licensing program started. So if you look at our different programs, that would be, I think, 1925 for the Real Estate Commission, 1991 for the Board of Real Estate Appraisers, and 2007 for the Board of Mortgage Loan Originators. So technically you could file a complaint about a real estate transaction involving a real estate broker back in the 1950s. I will tell you that the older the transactions are or the complaints are, the more challenging they are to investigate, because each of our programs has record keeping requirements. And to safely kind of say, those record keeping requirements for each of them are under 10 years. So if you're filing a complaint from something that happened 30 years ago, chances are the licensee that we're dealing with is probably not going to have those records. And then you're also dealing with, if there were witnesses, their recollections are typically not very fresh, they're cloudy. It just really becomes challenging to try to investigate old complaints. So you definitely, if you want to wait until your transaction closes, that is fine for us. We will still have, as long as we have the licensing program still in effect, we can still investigate it.
Awesome. Great information. Thank you. What role can and or should a local realtor association play in the complaint process?
So the local associations, and this isn't just for the real estate brokers or the realtors, it goes for any of our trade associations. So that includes the appraisers and also the mortgage loan originators. They can encourage people to file complaints. They can file complaints if they believe there's wrongdoing going on, but they don't get to play an active role in the investigation itself. And we actually really cannot communicate. When there's an active investigation going on, you're not going to get any information out of us. So if you're just kind of a curious bystander, you're not going to find out any information from us. We will communicate with the complainant and also the respondent. But, if a trade association just wants to know because they've got like a corresponding ethics complaint that they're looking at, never the twain shall meet. So we're going to deal with our stuff. The trade association needs to deal with their case.
Very good. And I know you mentioned that we do accept anonymous complaints. This person would like to know, do anonymous complaints actually get followed up on?
So we do investigate them. The one suggestion that I would make, if you're going to file an anonymous complaint, and we totally understand why people do these, is you need to be as specific as possible and provide us with as much information as you can, because we don't have the ability to be able to follow up like we would with the regular complaints where we have a named complainant. With an anonymous one, we're not going to be able to do that additional follow-up with a complainant. The other thing that comes up from time to time with anonymous complaints is that once we have done our investigation, the person who's filed it anonymously, and we don't know who they are, they then want to know what the status of the complaint was, and we can't give you that information because you were not the named complainant. So keep that in mind when you're looking at doing an anonymous complaint. I do know that a lot of our licensees will choose to file complaints against each other anonymously because there's a fear of retribution, and members of the general public will do it less often, but it is definitely something that we will investigate.
Great. And you touched on this, but I think it's worth following up in this context. The question is, how do they investigate brokers who do not follow any of the deadlines in a contract during a transaction?
So when brokers don't follow the deadlines or they're not paying attention to the requirements of the contract, basically how we're going to view that when we're looking at the complaint is that it appears that the broker is being unworthy and incompetent. So it'll get assigned to an investigator, And if the investigator goes through the investigation and finds sufficient evidence to prove that there was a violation, it may not just speak to unworthiness and incompetency, like they were, the broker was messing up with their job duties. It could also speak to brokerage relationships as well, just depending on how they are managing that transaction.
Okay, great. What are some of the frequent complaints that brokers can avoid?
So some of the common ones that we get for the real estate brokers have to do with disclosing material facts. And the big thing for the real estate broker to understand is when you're dealing with an adverse material fact, it's better to disclose and allow the consumer the ability to make the decision of what they think is adverse rather than the real estate broker making that decision. Because what we typically find out in our complaints is that a real estate broker thinks, oh, this isn't such a big deal and I don't have to disclose it, when to the consumer it was a huge deal. So disclosure of material facts. There's also conflicts of interest. So if I'm going to represent my son in a real estate transaction, I need to be disclosing to the other side that I'm a real estate broker and I am related to, whether he's the buyer or the seller, that there's that conflict of interest there. Brokerage relationships is an area where we see a lot of violations at, and it's just brokers not performing their duties or not performing them appropriately. And that has a lot to do with whether the broker is a single agent or a transaction broker. I think those are pretty much some of the common ones with the real estate brokers.
Okay, thank you. My next question is, when a frivolous complaint is filed against a realtor, does the realtor have any recourse against the complainant?
So I'm going to make one clarification, because I know it's pretty typical with the general public to refer to real estate brokers as realtors. Realtors are a member of the National Association of Realtors, and that is a trade association. We don't license realtors. We license real estate brokers, and that's how we see them as. They are all, if they're licensed with us to perform licensed brokerage duties, they're all real estate brokers. So just to make that clear, we don't have a statute like they have on the criminal side about making a false claim against somebody, or it'd be called false reporting in the criminal realm. So there isn't any recourse if somebody files a frivolous complaint against you. I will say, because I started out with the division as an investigator, the investigators usually can pick up pretty quickly when one of those complaints appears to be frivolous. And people file frivolous complaints for a lot of different reasons. It may be retaliation. A lot of what we see is that it stems from maybe a soured business relationship. Divorces are a common source of complaint. So those are things that the investigator, usually through the course of an investigation, may pick up on, but they're still going to do their job and evaluate the different claims that fall within our jurisdiction. And their job is to, neutrally gather the evidence, submit the facts, and then that way we can make a neutral decision as to whether there was or was not a license law violation.
Great. Thanks for making the distinction between realtor and broker. I noticed that in there. I'm glad you caught it. Thank you. Can I withdraw a complaint after it has been submitted?
You cannot withdraw a complaint. We will continue on with the investigation. So if you're trying to use a commission or board complaint as leverage of getting your way, maybe in a civil case, or getting restitution paid or something, once that case is submitted, we're going to investigate it. So you can't just come back and say, hey, you know what, they refunded my money, I don't want to go any further with this, please drop the complaint, because it's not going to happen.
Can the division force a complainant to cooperate with the investigation?
So we can't force somebody to cooperate with an investigation. It can make it very difficult for us to investigate. And hopefully, if you're going to file a complaint with us, you're at least going to speak to the investigator and provide us with any additional information that we may ask you for. But we do have cases where complainants file a complaint with us and then they kind of seem to drop off the edge of the earth and we hear nothing further from them. And it just makes our job a little more challenging.
So, Will anyone from the department or the division intervene in my current circumstances as a complainant?
So we can't intervene in your transactions, and this comes up fairly regularly. Probably one of the most common consumer complaints has to do with a real estate broker. If they're going to be your single agent, you have to sign a contract with them for them to provide those brokerage services. And they may ask you to also sign a contract, even if they're just going to be your transaction broker. So if you sign one of those exclusive right to buy or exclusive right to sell contracts, and then later on you decide, hey, I don't want to work with this person. Well, you've got a legally binding contract now, and you can't just tell them to let you out of it. They're going to have to agree to it. And if they don't agree to it, then you're going to have to consult with an attorney. An attorney may or may not be able to get you out of that contract. So just keep that in mind. But that's one of the common complaints that we hear is that, they won't let me out. And so they'll contact us wanting us to then get them out of that listing contract. And we do not have the authority to intervene in contracts. So it's just not going to happen. Or, make them stop the transaction because I have remorse. I don't want to sell my house. We can't do that either.
Okay, great info. Are complainants notified of any disciplinary action that's handed down by the commission against a respondent that they complained against?
So they are notified. However, I would probably encourage a consumer to take a proactive approach just because of the sheer volume of disciplinary actions that we deal with and how long they can take. Because we have some cases that when they choose to go through the Office of Administrative Courts, there's a delay in even getting those cases filed and heard. It could be years after you file a complaint that it finally gets through that process. So I would definitely take a proactive approach and reach out to us if you want to know the status of where your case is at and what's happening with it.
Okay, great info. So if I strongly suspect that my broker has violated the license law, but I don't have any physical evidence of that, should I still file a complaint?
You can definitely file a complaint with us. And I mean, we've got the ability because of the statutes and regulations. We have ways in order to get evidence that may or may not support, whatever concerns that somebody has. The important thing that I think you guys need to keep in mind when you file a complaint with us, though, is the information that we gather is for our purposes. It's not to aid you in your civil case against one of our licensees. And that further speaks to the statutes that say that our records are closed to the public except for the final agency orders or the stipulated agreements.
Okay, good to know. As a complainant, will I get to speak to the commission or board about my complaint?
So licensees and complainants do not get to have a moment with the real estate commission and discuss their complaint. Who you do get to talk to is the investigator. And in some cases, sometimes it will escalate up kind of the chain of command to the lead investigator and sometimes to me. But no, you won't be speaking to the commission or the board itself.
Great. Will the investigator act as a mediator between myself as the complainant and the respondent?
We do not mediate disagreements between licensees and the consumers. That is not a role that any of our programs have.
Okay. What information and or documentation that I've provided to the division as a complainant will be given to the respondent?
So we don't release to the respondent any confidential information. So if you've submitted, occasionally medical records get submitted to us or financial records, we are not going to provide a copy to the licensee so that they can provide their complaint response. Typically what we see though is like with a real estate or a real estate broker complaint, you may submit copies of your contract documents and we will provide copies of those to the respondent so that they've got that information when they are drafting their response and providing their additional materials to us. On the appraiser side, typically what we'll see is a copy of the appraisal report. So we'll provide a copy of the appraisal report to the appraiser so that they can provide their response. A lot of times what we'll find out is the copy of the appraisal that's submitted with their complaint isn't actually the final version of the appraisal. So that kind of helps the appraiser identify, well, wait a minute, that's not the final version. And that's something that they will then submit to the board for its review. And really with the mortgage loan originators, there's just kind of a variety of information, but if it's confidential and it contains personal identifying information, that's not going to get shared with the licensee.
Good to know. If I lost money because of the circumstances described in my complaint, will the department or the division assist me in recovering those funds?
So only one of our regulatory programs has the ability to impose restitution, and that's the Board of Mortgage Loan Originators. It doesn't happen very often that they impose restitution, just because usually with the type of complaints that we get with a mortgage loan originator, it would be really difficult for us to be able to calculate what the restitution would be. And an example of that is, my mortgage broker wouldn't talk to me. I lost my loan lock, and then the loan rate that I got is, a percentage higher. Well, we're not going to calculate the difference between the two loan percentages and then give you the restitution for that. I have never seen the board do that. The other two programs, the real estate broker and the real estate appraiser programs, do not have the authority to impose restitution. There are times when maybe the commission or the board will say, hey, one of the ways that you can resolve this is by, giving back the complainant the fee that they paid you for your services, and they might agree to do that, but they can't force somebody to do that. It can just be kind of a negotiated settlement term.
Great info. A licensee of the division was very rude and offensive to me. Should I file a complaint?
So being rude and offensive is a business issue. It's not a regulatory issue. So that's not something that we're going to have jurisdiction over. I mean, at some point, if they're rude and offensive to customers, they're not going to have any business, and that's just kind of how the business world is going to weed them out of probably practicing in their profession. But we don't have jurisdiction to address those issues.
And what type of conduct can lead to a licensee having their license suspended or revoked?
So usually if your license is suspended or revoked, that's pretty egregious behavior that is landing you in one of those two areas. Suspension could be a pattern of conduct that just continues and you're not fixing it, and revocation can speak to that as well. A lot of the time when you see somebody get their license revoked, it's because they have done something that has caused significant consumer harm. So like if you have a real estate broker that steals money from their trust accounts, that can lead to the revocation of their license. The appraisers are unique for us because we do actually regulate their ethics. So one of the things that we will occasionally see, although not very often, is if an appraiser lends their signature to somebody else and allows them to sign reports. That is something that I've seen the board revoke an appraiser's license for. On the mortgage side, I've seen licenses revoked because mortgage loan originators have forged documents. So they will falsify income on loan applications. That will lead to a revocation of their license. Suspension is usually something where your practices are far afield, but the board or the commission feels like a cooling off period that is punitive will sufficiently address the behavior and cause the licensee to kind of rethink their actions and adjust them so that they are in compliance after they complete their period of suspension.
Okay, some good scenarios for licensees to be wary of. So those are all of our pre-submitted questions. Thank you for everybody who submitted questions beforehand. We did have just a couple questions come in during your presentation. This person would like for you to either define or maybe clarify the meaning of preponderance of evidence.
So there's basically the preponderance of evidence is enough. We've got enough evidence and support to cause a reasonable person to believe that something was done wrong, is I guess basically how I would describe it,
Okay.
versus the beyond a reasonable doubt where the case is so solid that the outcome, you would not think that there would be any alternatives, to kind of put it in like layperson's terms.
Okay, great.
So enough, basically we have enough support that, kind of the threshold that we typically look at is that like 51% of the people would think that there was something wrong.
Gotcha. 51%. That's a good standard. Would the licensee file a complaint against themselves?
We do have that, and that comes up typically because of criminal convictions. So there is a requirement for our 3 different programs that if you've gotten in trouble with the criminal justice system, you've got a reporting requirement. So like if I pled guilty to 3rd-degree assault yesterday, depending on which board I'm licensed under, I've got a certain period of time in which to report. So that's pretty typical when we'll see somebody self-report.
I think this was connected to another question the same user submitted. What does a licensee that has been convicted of a felony need to do? How does the employing broker handle this situation? So you're saying for the individual licensee, they would file that complaint?
So yes, you need to notify us. With the real estate brokers, you have 30 days to make that notification. There's really not the employing broker standard as far as criminal convictions are concerned, although you probably want to alert them to it, because then you're going to have a complaint open and they're going to become aware of it at some point. But yeah, definitely you need to notify us. And also bear in mind that we don't cover every criminal offense possible. It's very specific ones. But to err on the side of caution, if you don't know if it is one that you have to report or not, you can go ahead and report it to us. And if it's not something that you have to report, we're just going to close it out at intake. So for one that comes up regularly for the different license types is, I got convicted of DUI. I'm reporting it. Well, driving under the influence isn't listed as one of the offenses that you have to report post-licensure for any of our licensing programs. If it's vehicular assault or vehicular homicide, that is something that you have to report, and those 2 crimes are typically connected to driving under the influence.
Okay. Marcia, those are all the questions that we've been asked to ask you. So thank you so much for your time.
Well, thanks, Jeff.
And Marcia, I did have one question that someone emailed me, if you have time for one more.
Sure.
And you may have touched on this earlier, but the attendee wanted to know, this is going to be the first time I'm going to hire a real estate professional. What due diligence do I have to take to find out if they've been disciplined before?
So you can go onto our website and query their name and see if anything comes up that way. And even if nothing comes up as them having any previous action, you can also send us an email with the licensing's name and ask us if they've had any prior disciplinary action, because not everything shows up when you do a name search in our licensing system. And if it's something where they have had like a stipulation for diversion or some other type of board or commission action that just doesn't show up on the website, we can let you know what that is if you email us.
Great. Well, Director Waters, we want to thank you so much for this presentation, especially all the time you put in for the Q&A. There were a lot of questions. And this is a lot of great information for consumers if they do have a complaint and they know how now this investigation process works. And everyone that's in attendance or anyone you want to pass this on to, please note that this will be recorded. Give us a day or two, we'll put it up on YouTube and we'll have the link for you. So we want to thank everyone for attending today. Thank Director Waters for taking the time to do this in her series of Directly from the Director. And we want to wish everyone a safe and enjoyable holiday season. So thank you.
Thank you.
See if I can